The law is complex, but it doesn't have to be a mystery. We are talking legal literacy, not advice. So don't worry, you're not getting an invoice. I'm Simon Jenga, and welcome to Simon Says. Today we are talking about distributions under a will. Now, I'm not going to cover distributions that would happen automatically under the Administration Act because that's covered by a separate video. This today is just focusing on positive distributions that you choose to make in a well-drafted will. Now, we're going to have specific distributions, and then there's also what I would kind of call catch-all or residue clauses. Another way they're often described as a remainder clause, and those are really designed to catch whatever's left in the estate after your specific gifts, make sure that everything is distributed out. It's really important to have that catch-all at the end, particularly just in case one of your specific gifts fails. So for example, I leave my car to my parents pass away before me, my car needs to go somewhere. The purpose of that residue clause is to make sure that my car is going to be distributed to someone that I want it to be distributed to. So that's really critical. Now, if we just go back to specific gifts under a will, another word that you might hear bandied around with distributions, gifts, is bequests. Now, that's the old way that we used to describe gifts under a will, but now we tend to use gift or distribution. So when we're looking at specific gifts, it could be chattels, so vehicles, furniture, jewelry, tools, those kinds of things. But it could also be specific gifts of cash, specific percentage gifts of your estate. You might want 10% of your estate to go to Bob, 30% to Nancy, and 60% to William. So specific can be specific items, but it also can just be specific amounts. If we're talking about specific items, then it's going to be that thing going to that person. So if I had a painting that I wanted to give to Bob, and I say, I give the painting of Mount Everest to Bob, if I don't have possession of that painting when I pass away, that gift simply fails. Nothing else happens other than that I'm not authorized to give Bob that painting because I don't actually own it. So any specific gift that you have in your will, if it fails, it's as if it's just not there in your will. What that means is that you might have drafted a will 10 years ago. You might have had a bunch of specific gifts in there. Even though you've changed your ownership of various items, you might not own certain things anymore, it doesn't mean that your will is void or defective. It just means that when you come to review your will, you need to make sure you've turned your mind to the fact that you don't have those things. So an example of that would be that you want to leave that Everest painting to Bob and you want to leave your painting of the Uraweras to Stacey. If you have gotten rid of your painting of Everest, then you might now want to change to add something else that you want to give to Bob. So that's the critical element, is knowing what's there, knowing what you own, and making sure that it's lining up with what you want to happen after you pass away. One of the common things that we get around chattels is when parents have both passed away and they leave their chattels to their children. There might be 2, 3, 4, 5 kids involved, and the chattels need to all be divided up. Now, generally, there'll be a standard clause that leaves everything in equal shares to the kids, and it's really up to them to make sure that they work through a division of those assets. There might be a technical position where the executor is actually responsible for overseeing the division of those assets. But in reality, often what happens is that families gather around and then they have a bit of a hooey, a bit of a meeting to work out who's getting what. If there is a dispute, that's when the formalities kick back in. So depending on whether you have specific wishes around who gets what, is going to dictate whether you decide to have a list of items in your will and who they're going to, or whether you just have that more general clause that leaves it up to the people left behind to figure out how to divvy everything up. Now, generally speaking, if we're then looking at the residue of your estate or what's left, It's going to include things like bank accounts, it might include property, land or houses, and you've got two broad options. One is to divide everything up in percentages to people or divisions amongst people. So you might say, I leave everything in equal shares to my children, or I leave 30% to child number one, 30% to child number two, 20% to child number three, 20% to child number four. You can kind of chop and change how you want to break down the residue of your estate. The critical thing is to make sure that there's sufficient backup clauses so that if someone is not able to receive their gift, that it's clear who it's going to go to. So if it's to your children, then maybe if one of your children has passed away, then it would go to their children, your grandchildren, through that lineage. If there's no grandchildren, then it might revert back to the other children, divided amongst them equally. So that's a fairly common structure that we see. But if you don't have kids, if you have a complex situation in your family where you might not want to leave everything to your kids, then those distribution pathways are going to become really important to make sure that you've got that kind of, what would you call it? Maybe a little web. If not this person, then this person. If not that person, then this person. And as I alluded to before, you're only distributing what you actually own. So what are some things that you don't get to distribute by will? Really easy, things that you don't have any ownership interest in. For example, the Harry McCleary statues down at my local park, I can't give them to my daughters under my will because I don't own them. It starts to get a bit more complex when you have assets that you own jointly or in shares with other people. So if you own assets jointly together with someone, then they will pass by survivorship automatically to that other person. Joint bank accounts, property that's held in joint names, those will automatically pass to the survivor. That means that they are not included in your will and you don't get to distribute them to whoever you want under your will. Assets that are owned in separate shares, 50-50 on the title of the property, bank accounts in your sole name, KiwiSaver, these are all examples of things that are yours to distribute by your will. And you get to choose. Do I give things unconditionally to ABC, or do I put conditions on certain gifts going in certain directions? The biggest consideration when you're putting a condition on a gift is whether it is enforceable, whether the person can actually get around it or hoodwink the condition that you put in place, because there's no point trying to put a restriction on a distribution if there is physically a way for that person to be able to circumvent that condition. And sometimes that's my job, is looking at a will, acting for the beneficiary or the person who's receiving under that will, and seeing whether there's a way to circumvent some kind of restriction that was put in place. It does happen. So my focus is on the front end. What is it that you're wanting to achieve by putting a restriction in place? And that might be something like, I give everything to my children upon them turning 25. So until they're 25, the assets are going to be held back. Now that's a restriction that's fairly common and is unlikely to cause too much drama for the people left behind because it's pretty reasonable, it's to be expected. If the condition was something like, I leave everything to my son on the basis that he enters into a relationship property prenup agreement with any partner he is with at the time. Now that's one where potentially the son is going to be able to enter into that agreement, receive the funds, immediately decide that he doesn't want that agreement to have effect, go about exiting or terminating that agreement, and then the funds go into the relationship with his partner or whoever he's with at the time. So although the condition may have appeared to achieve its purpose in the first instance, in reality, in practical terms, maybe it's actually not going to do what you want it to do. So part of my job in talking to you about that is how do we achieve your goals in ways that are tangible and are actually going to have an impact when you're gone. So today, Simon says, when you're putting together the distributions that you're making in your will, You need to consider what specific gifts that you want to make, who you want the balance or the residue to go to, and what, if any, conditions that you want to put on those gifts and whether they are actually going to be enforceable when you're gone. For more legal insights, check out our other episodes, subscribe to our channel, and remember, at LOA Law, we are good lawyers for good people.